welcome back to Open Your Eyes on a very, very cool Wednesday morning. We're about to kick things off with one of the hot topics that have been resonating over the past 2 weeks, I'd say 3 weeks. Equal Opportunities Draft Bill. Now, in to talk to us about it, we've got Judith Alpuche, who is the CEO in the Ministry of Human Development, Social Transformation and Poverty Alleviation. And also in with us this morning is Rashad Brathwaite, who is an attorney at law and consultant. Guys, good morning and welcome. And allow us to say Happy New Year.
Thank you.
You
still can say that, right?
Yes. So, you know, this draft bill has definitely been hitting our country like a wildfire, and I think more so because of all that is within the bill. For the most part, a lot of people are seeing one way out of it. I think what we need to do is to provide some clarity so everybody could get on the equilibrium with what's going on with this bill. Once again, good morning, and let's jump on into it. CEO, please.
Yes, and thank you so much after that introduction for having us and for allowing us the space to really talk about it and educate. And you know, the media is an invaluable ally and tool in this regard to try to get to address some of the issues. So we've done the public consultations and as was said, and we've listened very keenly and intently to people's concerns. And just to say from the onset that what we're trying to accomplish with this Equal Opportunities Bill is to give life to our Constitution. It is really to operationalize those promises that are set out in our Constitution that speaks to the fact that we're all equal under the law, and that in certain categories are laid out where we should not face discrimination. Age, race or ethnicity, religion, sex, etc. And so it's really about how do you operationalize that? How do people access that? How does the government be proactive in really creating enabling environments, setting up frameworks where people don't face discrimination? And we have been talking about this for a long, long time in the sector. Marlene, you know, being in the sector, we started these conversations in earnest around stigma and discrimination having to do with people living with HIV and AIDS. And I can remember as a child protection worker, you know, having to deal with the fact that some children could not access education, not because they were positive, but because they were orphans due to HIV and AIDS, or because somebody heard some rumor that a parent was HIV positive. Whether or not that was so was another matter. But children would face incredible discrimination, much less those living with the disease. And we, you know, we've talked about this, about how stigma and discrimination really drives people underground, not accessing proper health care, etc. So that's the reason why, too, the National AIDS Commission is leading this charge, because those conversations have happened for 2 decades within that space. But we've also noted that as we look around in sectors having to do with women, children, persons with disability, etc., that you see other manifestations of discrimination. And so instead of, you know, just using the CARICOM model bill that this, our Equal Opportunities Bill is based on, instead of narrowly putting something forward that just deals with stigma and discrimination having to do with HIV/AIDS, we looked at 19 other characteristics for people who are experiencing discrimination in various ways. Or some of the things that we had to deal with in terms of, you'll see a number of issues having to do with maternity, pregnancy, breastfeeding, family responsibility, which disproportionately affect women, especially as we're living longer. Women of my age are being squashed in between child care and the care of the elderly. So how do we balance all of that with the realities of having to put bread on the table? So because of that, we said, let's do something more comprehensive. And we were lucky enough to get Rashad on board.
You know, I think what you're opening with is perhaps one of the critical parts of the conversation that we've not heard, at least publicly, which is looking at the evidence that is driving the need for the legislation. You know, we talk about stigma and discrimination. I think it's a very loose term, but there are actually practical ways that people have suffered or gotten the wrong end of the stick in this country. So let's talk about what data does exist that showed that there was a need for this type of legislation.
Hi, good morning, and thank you for having me. I've really gotten to see over the course of the public consultations the beauty of Belize, so truly it's an honor to be here. So let's talk about the data. Firstly, we start with the high levels of prevalence. So for 240 to 250 infections annually over the last 10 years or so, and the mortality rates being about 110 to 130 persons who are dying from HIV. In a world where HIV of 1990s and 2000s, with the medicine that we now have, need not be a death sentence. And so the stories of persons who, because of the stigma that is associated with going to the healthcare facility. So before you leave the testing facility, your result is known in the community, or even the fact that you went to a particular facility, because that is known as the place where persons with HIV go for service. So people have left. I was listening to a story as we moved around. Some person said, look, you know, I've got someone who, because they did not want to have to go through all of the rumors associated with accessing healthcare, died leaving 4 kids in a world where that is not necessary. So that's the HIV data. There's a human rights monitoring framework, a shared incident database, for which there's evidence of in the last 2 years or so, more than 250 instances of discrimination. And these range from physical violence, breaches of confidentiality, evictions from accommodation, terminations from work. And so there's a considerable body of evidence related to HIV. PANCAP and other agencies have been doing incredible work in attempting to build the evidence base for the ways in which stigma and discrimination affect persons living with HIV, but this isn't just about HIV. We've looked at the levels of female participation in the labor force and where that is lower than many counterparts across the region. And then when we look into areas like the level of employment for persons living with disabilities, the level of employment for persons living with disabilities is incredibly low, and this is perhaps true across the region. And you know, for me, certainly on the question of disability, one of my closest friends, and you know, when friends are family, my cousin who has a disability and who, because he had parental support that could fight for him, having to negotiate, look, my kid is brilliant and it should be able to access mainstream secondary schooling, who now has 2 master's degrees, and is very much, you know, leading in his field. But what he was told is that because he had a disability, that he should attend a school that was not a mainstream school and that did not provide certification. So that's some of the.
But it took advocacy.
It took
on behalf of the parents.
And so where you aren't, not, you know, that's a child with disability doesn't have that choice about their parent. And so that's where the law becomes important.
Well, see, that's the question I have, because I think even on this show, we have had several conversations with vulnerable groups identifying situations of discrimination, from people from the LGBT community losing jobs, being evicted from their homes. We had a recent father who spoke of you know, his son being discriminated at work to the point where he stopped taking medication and eventually lost his battle with HIV. We have had conversations with people about breastfeeding in the workplace. We speak very often about women and their challenges in terms of being able to maintain the household and keep their work going. You know, I think that these instances do exist, but my question is, even with disability, for example, there are other policies that already exist for inclusive education, for breastfeeding in the workplace, for equal access to education, and in some parts not being discriminated for your HIV status, right? So why is this an essential component to be added to our legislation if these policies already exist?
You
have.
It's really, I mean, we've heard that question, and a part of it has also been, but the legislation isn't working, or you know, these policies. So this is about how do you put forth a mechanism to assist with these situations, because even when things exist, like even when you have precedent, for instance, like I'll take like the Maria Roches case, you know, that clearly that's established, but yet you still hear teachers saying that they have been fired and they are not able to access the courts for judicial review, so they just give up. I know of one woman who left the country, really good teacher, left the country because she didn't even want to start this fight because she thought she would lose, you know, and she didn't have the wherewithal. So this is where, you know, a part of what I like about this legislation is the whole positive obligations also that it puts on the states to look at these frameworks. A classic example, for instance, of laws that have already been in place but don't work is our Sexual Harassment Act. That's and Mr. Brathwaite has said this is like a really good piece of legislation, but there's no mechanism for it to work, and so it's never been used. And you will not tell me that sexual harassment does not exist in Belize. I have heard and overheard the stories,
and many of us have experienced it.
Indeed, many of us have experienced it. But so it's how do you operationalize these things? You know,
wouldn't we say that? You know, it's hard to try to put to mind that as much as some of these things are already being tabled, for instance, sexual harassment, and they're not being looked upon as serious as they're supposed to be, wouldn't we then say that, you know what, that's the onus of the authorities? Because look, what this bill actually does, it actually clears the path now for generations two. For when they get into it, then eventually we'll have a freer world. We talk about free world, and we've heard, especially in the mighty USA, that these things are already being enrolled. I still boil down back to my question, wouldn't we say the onus is on the authorities to make sure that these things are being dealt with?
So the bill is 75 pages, but section,
I've seen it.
there are 127 sections. Sections 55 to 127 are about the operation of the commission and the tribunal. Because the strength of the institutions, that's significantly important. So firstly, let's talk a bit about the public sector equal opportunities duties. And this is new. There is no other jurisdiction in the region that places a positive obligation that can be enforced on public authorities in the conduct of their work to have due regard to the need to eliminate discrimination. And that might mean looking at the ways in which your budget allocations are functioning, your programmatic directions. And so when you are working and there is an uneven rural-urban divide, which then may interact with ethnicity and race, there is now a mechanism for review. And the Commission has significant powers working with other government entities to request reviews for compliance, to provide compliance notice. Look, we need to see this plan that shows the ways in which you have considered this. And evidence from where positive obligations have been implemented demonstrates that that exercise, that yields significant results in the way that public authorities engage with their work, because they have to think about these things. Reasonable adjustments for disabilities. This now places an obligation on an employer to make those changes where it doesn't result in an unjustifiable hardship, meaning a disproportionate burden. In many cases, what is required in order to allow for accommodations and adjustment is thought. and we can think through adjustments and accommodations. There are those that are free and require thought. There's those that are relatively inexpensive and can be quickly implemented. But there is nothing that says, if the choice is, I will hire someone that doesn't have a disability so that I don't have to deal with any of this, then that becomes the choice.
But how does the bill reduce the burden of proof? We have instances in this country where people have lost their jobs because their HIV status has become disclosed. And that's two issues. That's one, losing your job, but also the confidentiality issue, which already exists in the healthcare system, that you should not say who's been tested, who's positive, or who's negative. So that already exists. But when you talk about going to a labor force tribunal, for example, as one of the current instances, or even if it's sexual harassment and the confidentiality issue comes up, does this help in terms of being able to reduce one of the greatest challenges, which is being able to prove that they didn't want to hire me because I'm pregnant, or they fired me because I'm HIV positive, or my child is too sickly, so they fired me because of that reason?
So the legislation addresses this in a couple of ways. Firstly, there is a body dedicated to investigation in the form of the commission. So that firstly, the commission, and we've been very much trying to emphasize this, that the commission is trying for alternative dispute settlement so that we don't have to end up at court. But the commission provides a free mechanism for the investigation of complaints so that the commission can dismiss a complaint if it is trivial. But substantively, what we've really spent a lot of time, certainly I have, in looking at what are the mechanisms that have worked across the world to increase transparency and to allow for better engagement. So how does this work in this context? Firstly, the Commission has a statutory questionnaire which will, when a claim is raised, an employer service provider will have to reply to this questionnaire in response to the allegation. And so where it is that there's one thing that's been told to the individual, another thing that's been told to the labor officer, and then something else that now pops up in response, we're seeing some variance in the duty holders' responses, and the court can take into account to make an adverse inference on the basis that there's something that is not adding up here. Now, and this is true of constitutional discrimination, what I'm about to say. It was recognized that when you brought a constitutional claim for discrimination, if you had, or breach of any right, if you had to prove the breach of the right, that it was almost impossible because the state authority was usually the one who had the information. So what this legislation does, which when you're doing any case relating to a breach of a human right protected under the Constitution, is that it reverses the burden of proof. If you have established that there is some merit in this case, the burden then shifts to the duty holder to say, look, I did not act in a discriminatory manner. And so let's say in the case of employment, if there's a clear criteria for hiring, we've looked at qualifications, we've looked at the strength of your application, we've looked at your cover letter, and there is a clear, transparent framework, then it's very easy to say, look, you were not the most qualified candidate. But where it is that you've got, you are clearly the most qualified candidate, and there's no other substantial barrier, then why was this woman not hired? That becomes a real question. Now, it will always, and anywhere where anti-discrimination legislation or equal opportunities legislation is in place, it is always difficult, this question of evidence. But what we know is that by providing these sorts of framework, it gives persons who've been discriminated against a fairer chance to bring this to light.
So for those who are willing to take on the fight, because that's also one of the challenges.
Better than that, we've been, so firstly, the Commission, in exceptional circumstances, where there might be a case of systemic discrimination, or, so often there is a video that comes out of a clear instance of discrimination, but individuals may say, look, I don't want to move forward with this because I will not be the martyr for this cause. The Commission can bring an action on behalf of persons. Significantly, there's been a whole lot of work in the region about who can bring a claim. And so we've extended the protection so that an organization could bring a claim on behalf of an individual. So your union might be best placed to bring this. If you are being discriminated on the basis of religion, a religious organization may be best placed to bring this, because this is an issue. Discrimination is not just an individual question. It is about the way in which persons who belong to a group feel, so that when a person is discriminated because they're a person of faith, then other persons of faith likewise may fear that that is acceptable, and that their right to freedom of religion might likewise be affected.
This particular consultation for the Equal Opportunities Bill falls at an interesting time. It was very recently that the Court of Appeal reaffirmed the ruling on Section 53. And I think that that has kind of been the entry into the conversation, where a lot of the focus on the Equal Opportunities Bill has been on the LGBT community and how some religious institutions feel about how much that affects their personal beliefs. I want to take the opportunity to get into that. We've seen the National Evangelical Association of Belize speak out publicly. In fact, they're the only religious institution to do so. Have you approached other religious institutions, the Roman Catholics, for example, who are in fact the largest denomination in this country, about 40%. So they represent 40%, based on the old census, 40% of the people who subscribe to that faith. Have you been proactive in being able to speak to other religious institutions to get a sense of what they're feeling on this issue?
Yes, we did, as a matter of fact, have a meeting with the Belize Council of Churches this week. My days are running together now. To talk about the issues, and they had some of the same concerns around religious freedoms, etc. But even prior to drafting this bill, Mr. Brathwaite was in country and spoke to people, and the whole issue of the religious freedoms came up, and so you will see the protections are very strong. Very strong in the draft, no? We were able to put together a document that addresses all the issues that we have heard in terms of the religious concerns. So
let's get into some of these. One of the first assumptions is that this allows for people to, the LGBT community, to get married. Same-sex marriage is now allowed if this passes. True or not true?
Not true.
Not true.
We've provided now explicit coverage in the legislation that provides that nothing in this legislation affects the operation of the Marriage Act. The legislation never could have affected the Marriage Act because this legislation doesn't regulate marriage. So there's a provision that says if any conflict relating to a matter that is dealt with under this Act comes into conflict with a piece of legislation, another piece of legislation, that this legislation will prevail. But that requires for there to be an area that is capable of conflict, and we've added language just for clarity, so that, if I can very quickly explain the way that the conflict works. The labor code requires a medical when you start working, but it doesn't specify the nature of that medical. And so an employer very well may say, we need you to provide an HIV test. We know that that is not effective from a public health perspective. And the Equal Opportunities legislation, the HIV prevention and cure component, says that that's prohibited. So there's now a conflict between those provisions. In that event, the Equal Opportunities legislation must prevail, and it would be unlawful to request an HIV test in those circumstances.
So what you're saying, and you can correct me if I'm wrong, is that if the issue is addressed in the Equal Opportunities Bill, and there's another law that is in conflict with what is addressed in the Equal Opportunities Bill, then this is the overriding legislation.
This is the overriding legislation after 2 years.
After 2 years, okay. But what you're clarifying in terms of the marriage issue is that the Equal Opportunities Bill says nothing about marriage.
It does not deal with marriage.
Which is why it would not be an overarching legislation over the Marriage Act.
The only area of reference to marriage is discrimination on the basis of marital status, which is in accordance with the laws of Belize.
Okay.
And so, no, we don't regulate or attempt to address the question of marriage. Marriage remains
between a man and a woman.
Yeah. Yeah.
And one of the things too that really I think needs to be highlighted is that the religious protections there is its own protection against this kind of thing, because if your sacrament within your religion says that marriage, the sacrament of marriage, or whatever you call it, whatever word you use to call marriage, you can tell I'm a Catholic, so I use sacrament, says that that's between a man and a woman, then this protects you from that.
So you don't
cannot
have
be
to
forced
change what your denomination or religious affiliation allows for.
Yeah.
Now,
you can't be forced to, even if the Marriage Act were to change, this actually offers protection. Because it says, it offers you the religious protection that whatever you have deemed that marriage is between a man and a woman. That's what your religion says. So nobody can come and force you to perform that sacrament otherwise.
And to be clear, we are not changing.
We are not
changing the Marriage Act. We're not.
There is no attempt.
Yeah.
But it still comes to mind, because looking at some of the videos of the consultations, they're heavily serious, especially when it comes to that. And this might be of me to ask, but at what point? Because it's clear. You're saying it's clear. But if you go to a consultation, there's somebody of a naysayer. At what point was there a mix-up there, being that it's clear?
I will approach this very cautiously.
Please do.
I think the human nature is that when there's something new, naturally there's fear. And part of the reason we've produced a simple guide to the legislation is that the legislation is a comprehensive piece of legislation, and there are provisions in it that if you read it without thinking of all of the ways in which the legislation is connected and has to be read as a whole, you may miss things. And much the same way that it's necessary to read, if you are a person of faith, you read your religious text as a whole. And so the legislation...
But could it be timing too? Because I think it was only like a week before that Court of Appeal upheld, and the LGBT community said they would potentially look at exploring same-sex marriage.
And it got that added, I will say, that added to the anxiety. But this is something that has been on, we could not predict the time of the Court of Appeal's judgment. We had been working for some time now, and in earnest, like for instance, just to help with the timeline, we actually got cabinet sanction to draft this legislation February 26, 2019. And so the drafting has been moved, and Mr. Brathwaite's consultancy is also time bound. So in terms of, I will say that indeed I think that judgment heightened people's anxiety and suspicion and so forth. But really, we had no control over the Court of Appeal's judgment.
This was very publicly announced in terms of the champion of the legislation by the National AIDS Commission on February 28th as well.
But I don't want to mislead people either, that one of the identified vulnerable groups includes sexual orientation.
Absolutely.
So can you speak to that in terms of how that impacts other laws as well?
Right. So the legislation looking at, starting from the discrimination, the component of discrimination and stigma, we can't address HIV without looking at the key affected groups and providing protections in that regard. And so the legislation provides, for example, that in employment, that a person cannot be terminated based on their sexual orientation unless there is some legitimate reason for a person's sexual orientation to be a relevant consideration. And so religious bodies under this legislation, they have discretion for anything that is done in conformity with their religious beliefs or tenets. And this could include inherent, so it may matter for a religious organization, not just the question of sexual orientation, but marital status. Are you single, are you divorced, are you cohabiting? That might be a matter of consideration. And so the legislation says, ultimately, to bring this back to kind of a bigger picture of how can people of diverse experiences live in community. And I've been using this metaphor of an umbrella. And so if we're in this very confined space, exposed to the element, if I hold up my umbrella, I might not be able to hold it straight up if somebody's right next to me. You know, we tilt a little. And so the legislation provides a lot of provisions about that balancing. We've provided a factor to determine in terms of the exceptions. You may have different and less favorable conduct in an area that is regulated on the basis of a protected characteristic, but there may be an exception that is applicable to you. And then we've also provided for an exemption. Part of the exemptions framework is that it's fundamentally about notice and fairness. So we've heard concerns about, you know, a small bed and breakfast who may be owned by persons of faith, and they may say, look, we'd prefer only to rent 2 married couples in a room. That's fine, and you make a notice of that. But what ought not to happen is that a person flies quite down to Toledo or Dangriga to then be met on arrival with, look, we're sorry, we can't take
where there's no written policy in place.
Exactly.
Okay.
And so that's then a question of notice. Fundamentally, that's about fairness.
So let's talk about the protected characteristics, and that's an interesting term in itself. So we're not classifying groups. We're just saying that you may possess one or some of these issues and be discriminated based on them. So we're talking about age, we're talking about breastfeeding, disability, family responsibilities, gender identity, HIV positive status, intersex status, lawful sexual activity, marital status, maternity, political opinion, pregnancy, race, religious belief or activity or lack thereof, sex, sexual orientation, status as a person who's experiencing or has experienced domestic violence, status as an orphan, and any other status.
So let's perhaps start with any other status.
Yes. So
the Universal Declaration of Human Rights, it provides a range of protected characteristics, and it concludes likewise with any other status. What we do is we provide a framework for the possible expansion of categories where it is necessary to do so. And other status, a person can qualify under the framework of other status where it is discrimination that results in systemic discrimination. So this is ultimately a group question. It results in discrimination that undermines human dignity, and also it must be, the nature of it must be of similar seriousness as the other protected characteristics. And so we've heard concerns about maybe you should provide protection for irrelevant criminal record. So, you know, we, as societies, we can be unforgiving. And so a person has served their time and finds it impossible to get a job because you have to go to the police and you have to request your police certificate of character, regardless of the nature of the crime. You know, thankfully, Belize has moved on the expungement of convictions in relation to marijuana. But there are other, you know, there are a whole range of offenses that might be irrelevant to the job. Other status.
But that's not included.
Other status provides a framework for that to be included. So if that came before the commission and the tribunal, a determination could be made that this is another status.
But if it's a relevant issue, why not include it?
And we're working on it.
And it's a partly policy decision as well. So we're looking at, but an important part with you know, that Mr. Brathwaite had raised that I thought was very important in the past. With this other status, sometimes in frameworks, sexual orientation, etc., is brought under that. But we thought that it was important because we did not want to, as you said, put poison in the caldo. We wanted to be open. That was brought up quite clearly because we want people to see the full extent of what we're dealing with, because there's nothing to hide. All of this is based on reality and data.
Well, Well, and I think that that's perhaps, and even as reading the list, I know that there are people reacting to some of the issues on the list. Sexual orientation is only one. I think gender identity or transgender is something very new for the conversation in Belize. Intersex is also one. I'm trying to see what else is there.
Lawful sexual activity.
Lawful sexual activity. So let's tackle these issues.
So lawful sexual activity is included in the CARICOM model bill, and it's better, I've explained this with reference to what it doesn't cover.
Well, I was going to say lawful sexual activity has changed in terms of the ruling for Section 53, but there's certain things that remain the same.
And so ultimately, lawful sexual activity need not be thought of in relation to sexual orientation because there's explicit protection there. Lawful sexual activity in a culture and an era where kind of revenge porn exists in the way in which people's private intimate moments are leaked. So that's what's referred to as revenge. And where it is that is an irrelevant consideration to a working environment, that's lawful sexual activity. We've had, looking at it internationally, cases where persons work at competing companies and they are in a relationship and they've been terminated on that basis. And then lawful sexual activity could include sex work, speaking to the reality that there is
is sex work legal in Belize?
So that's a kind of technical question where Belize's legislation does not prohibit the selling of sex.
It does not prohibit.
Does not. If you are an autonomous sex worker, it prohibits everything else around it, like pimping, pandering, keeping a brothel, etc. But if you decide that personally, this is what you are going to do, and there is no madam, etc., then it is
working for yourself.
Working for yourself. If you're
there's a bit of an oddity in terms of selling is allowed, but buy-in is restricted. So that that's a later conversation. It's an odd legal framework. I agree. But ultimately, the legislation provides that if regarded as lawful, that when it comes to accessing insurance, when it comes to accessing banking facilities, that person shouldn't be discriminated on that basis. It's intersex status, simply where a person is born with biological characteristics of both sexes. So you may be born with ovaries and testes, and that's often...
Which is scientifically possible. It does exist.
And it exists in Belize.
Yes.
Because as I go, since I've known some of the stories, and I'm hearing more stories now with this of parents making decisions about this biological, and then finding out that maybe it was the wrong choice right here in Belize. People face discrimination in terms of access to medical care, etc. So.
Wow.
And then gender identity, the ways in which people express their sense of masculinity or femininity. So including transgender community, and starting from the framework of HIV and the high levels of prevalence is important. And if I can spend a little time on just breaking down the connection. If a person cannot work, if a person cannot access housing, the person will turn to other means to get housing and to get food. And so if you're able to allow persons the space to live and thrive in employment, to allow them to access education, so where it is that you may have a case of a student who's deprived of education because they may express themselves differently, then that translates into not being able to work, not being able to live, and so ultimately the society is driving that individual towards risky choices that result in higher levels of HIV prevalence. A concern here is that single-sex schools will remain single-sex schools determined on a biological basis.
So it means that if there's someone who wants to go to an all-girls school, they can't use the Equal Opportunities Bill to say, I should be allowed to go there.
No, so a biological boy can't apply to St. Catherine.
To St. Catherine, okay.
No matter how he expresses himself.
And for sure, this is a tricky area.
Yes, and that's what I wanted to get at, because as I said, some of these are introducing new concepts into a public conversation where perhaps maybe healthcare workers, counselors, or some of the school systems have encountered them on a smaller basis. How do you, and I'm sure this has probably been one of the bigger issues that you've had to bring up to people, that putting transgender or gender inequality in a legislation is something that perhaps people are not comfortable with because they don't want to accept that it exists in the country. So how does this apply? Why is it necessary to put it in the legislation?
Because the kinds of discrimination exists, and because the state has a duty to allow, to ensure that nobody is discriminated against. And a big part of this with the commission is also education. I think that's an important function in terms of doing the work to help people to understand these different manifestations and to understand the interconnectedness of things, as Mr. Brathwaite just pointed out. I mean, it's more than, you know, okay, so you can't go to school. It's how that drives everything else and how it drives you underground and how that then impacts on society as a whole. You know, and we're trying to respect that everybody, you know, everybody's umbrella, but everybody needs an umbrella in the first instance, and that's the duty of the state, that we can ensure and try to, as best as possible, ensure that your freedoms are not unduly are not infringed upon. But the fact remains that just because you come from a different ideology, or you pray differently, or you believe that this is a sin, this state does not have the luxury then of saying, well, we're not going to protect sinners according to your doctrines.
Well, and in fact, I think one of the things that I've seen, I suppose as a result of the consultation, is where you're going at great lengths to show how religious beliefs are actually being protected through the Equal Opportunities Bill. I have one example of looking at dreadlocks. And that has been a continuous part of the conversation. Rastafarianism is a religion. And I think in the last census we had about 500 people that identified. I don't know what this latest census will say. But talk about protections there, because it's not that that religious groups that have very specific beliefs are being robbed of those beliefs. They're in fact having a bit of reinforcement with the bill.
Exactly. So we've heard all sorts of, especially people of faith, and I understand this, you know, saying, will I still be allowed to preach? You know, I'm a street preacher. Will I be able to put up and you know, and tell people of the LGBT community that they're on the wrong path? And we're like, yes, that's protected. You know, you just have to, if your municipality wants you to get a license to use the public space, or you know, you're free to do that. Get your license, set up your thing, and because freedom of speech, expression, and freedom of religion is protected.
It is,
you did not include hate speech.
We did not include hate speech.
Do you feel the country is just not ready for that type of legislation?
So firstly, the criminal code already provides some protections in relation to threats of grievous bodily harm and you know, so murder, etc. So there's some protection there.
But it didn't include rape. We found that out very recently.
So some protections are provided already in that regard, and you know, we felt as though the protections in the circumstances were adequate, and otherwise that would now be a much broader discussion. And if we can just circle back to protection of religious beliefs, there is a diversity of religion. So whether that's denominational diversity or other smaller religious communities, the state has an obligation to protect all of these forms of religion. So whether that is traditional religions, whether that is established religions, emerging religions, the state has a duty to provide those protections. And fundamentally, that's part of this conversation has been about what duty does the state have in regulating sin within a tradition? And we've used the example of, look, fornication is very much legal, and regardless of whether it's considered sin.
Which means sex outside of marriage.
Sex outside of marriage.
Yeah.
But we've recognized in the Family and Children's Act that persons who are born outside of wedlock need protection regardless of their conception.
Yeah.
We've recognized that cohabiting unions, so
After
people
5
who've
years,
lived together for 5 years, even if unmarried, that they require the protection of the law.
Yeah.
And so the state provides this balancing exercise of umbrellas. And what we've attempted to highlight to people of faith is that it is important that your right to engage and to share your truth with others is protected, so that even if a behavior that you disagree with from a position of faith, that you engage with persons and you bring them to your light. And that's what's important that we've protected.
Can you respond to my dreadlocks question? So if I'm a Rastafarian and I have dreadlocks and my workplace doesn't allow it,
this legislation provides protection.
because that is my religious belief. That's a part of my religious belief.
We actually have the case of Imhotep Diego. Recently, who sought judicial review,
Which is a child,
which
right?
is a child in a school, because he has been growing his dreadlocks since birth, basically, and it's a part of his spiritual and cultural identity. And he was being forced to cut his hair to comply with the
School
and
rules,
he actually sought judicial review and won his case.
Wow.
And let me say that it could provide protection. Now, of course, everything is a case-by-case assessment. And
you'd have to prove.
And you may have, let's say that you may have a legitimate interest in a workplace where long hair could be a health and safety threat. Now, your aim here is safety. The legislation requires that there be a legitimate aim, that there be a measure that's connected to that, and that there be no less restrictive means of achieving that. Where it is that the aim might be noble, safety, the question is, might a helmet, might another way of covering the hair not provide that protection? And this is a Caribbean-wide conversation about the politics of hair, and so the legislation does provide potentially greater protection. But again, I just wanted to highlight that this is a case-by-case assessment.
It's not blanket. It's not once.
And that's why I'll say it again, I love the role of the commission and the positive obligations, because it's really heading things off at the pass. So it's really working towards more positive frameworks, so the same way we worked on the issue of HIV in the workplace and what does our workplace, how, these frameworks and guidelines for workplaces to be more inclusive and to reduce stigma and discrimination. It's the same way. What does an equal opportunities workplace look like? And you start to look at these frameworks. So because sometimes people are not even aware, it's not malice or malintent. It's just like a lack of awareness, or helping people to think through creatively.
Or a paradigm shift
some of these things. So that, I think, is a really valuable piece. The commission and its work in trying to set the stage so that we create these enabling environments. So we don't have to go to dispute resolution, and we certainly wouldn't have to go to the courts even.
So just two final points. One, what's been the engagement with the private sector? Because they have a very large stake in this.
Absolutely. I think we definitely, I know. There have been conversations, but there definitely needs to be more. Especially since now we have the draft, we have, to look at some of the specific issues that they will be thinking about. And that input is going to be invaluable as we walk this line, because we were talking about, like, for instance, the difference between maybe catering and just restaurant and food. So those kinds of things, the same way the difference between a bed and breakfast being run by the example of the bed and breakfast as opposed to a chain hotel, that kind of thing. So I think that it'll be invaluable.
So that's the next phase of your consultations?
We definitely are doing small group smaller group discussions after these public consultations.
And is this a consultation that will allow for changes to be made based on feedback?
Change is already being made.
Yeah, I've been, as I moved around the country, I've highlighted a personal value for me, and that's a generosity of spirit, and that means that our consultations are genuine. And so the changes were included in the first draft based on the consultations that I had. I've been to Belize in August and November. I've met with the Chamber of Commerce, for example. I've met with other commercial institutions, the insurance industry, supervisor of insurance, for example. And so we're very happy and receptive of how do we make this legislation not the perfect piece of legislation, but a stronger piece of legislation that is more apt for Belize's context. And so, submissions can be made to the National AIDS Commission. Hopefully we can display the website where, the email address and website where those can be made. And those are open until the 31st of January. And then if the bill goes to, has to go to cabinet and then to the national.
What's the timeline for that?
Once it closes, the consultation, our comments period closes at the 31st of January, then we'll really look at where we are. I think we have to go back as the Anti-Discrimination Steering Committee and look at this, because it's very important that we get this right. And so that's why I'm not closing off that we will continue consultations with small groups, because we have to get it right.
Of course.
It's such an important piece. It's such a forward-looking piece of legislation, and it can do quite a bit for our community and our society, and it's important that we get it right.
Well, we are completely out of time. We want to thank you for coming in to have this conversation. We touched on some of the issues, but I know that if you contact the National AIDS Commission, you can get an electronic copy and even some of the guidelines that you've put out already. So thank you so much for coming in.
Thanks for having us.
All right, once again, the closing date for feedback on the draft is January 31st, so you have to send in those comments before that date. We're going to go ahead and take a break. When we come back, we'll be talking about International Customs Day, so stay tuned.